Tiffany?
I can hear him now. Thank you.
Great, okay. Let's go ahead and go on the record. I'll admit everybody.
We are on the record.
I have this.
All right, this is Judge Basher. We are on the record. This is case number 23-218-508. If you're not actually speaking, if we could please have microphones, that would be helpful.
Judge Basher, your camera's off.
Sorry about that. Thank you. All right. And just for the record, this is being streamed on YouTube as public access, so it's just for everybody's information. You see Ms. Walpole is present, Mr. McNamara is present, and I think I saw Ms. Aguirre is present as well, but I don't have a microphone yet.
You know, can I just check my mic? I was having audio problems earlier. Can you hear me all right?
I can hear you just fine, sir. Thank you.
Thank you, Your Honor.
I can't. There's an observer that I don't know, and there's another name that I don't know.
Right. So I guess this is on for request for a restraining order. And I don't
An
have
injunction.
any responses filed at this point. I do have, so I don't know what everybody's position on this is, frankly. So let me. So Ms. Aguirre, what I'm going to do is I'm going to go ahead and listen to the arguments that are being made, and I have some questions to ask, and then I'll hear what your position is. All right.
540 restraint may be by an individual, of course, is a nonprofit. Love Overwhelming is considered an individual under the law. They're also an interested party. Love Overwhelming was received notice from the city of Longview as third-party notification, and in effect, Your Honor, this would be detrimental to Love Overwhelming's business operations, their ability to perform in the future, because they build the mission, the way they do the work they do is by building trust with the clients they serve. And
well, let me stop you. How do they fit into the definition of 4256-540? They're not a state agency. They're not an agency representative. And they're not a person who's named in the record, somebody whose information is being released, correct? Am I missing something?
Your Honor, they did receive third-party notification. This was information that they provided to the city. If I can have just a moment, please, to pull up that RCW. Okay, I can't get into Westlaw right now. So, Your Honor, 4256-540, first sentence indicates that any public record may be enjoined by not only an agency or its representative or a person who's named in the record, but to whom the record specifically pertains. And this clearly pertains to information given, provided by Love Overwhelming. They provided the release of information. They provided all of the data.
But how does the information sought to be kept unreleased pertain to the agency? It's not an agency record.
Your Honor, actually, these are considered, and if, Your Honor, actually, if I can have just a second to try and get into Westlaw, because there's a case that I would like to bring to the court's attention.
When I looked it up, what agency definition, any non-governmental party seeking to block disclosure or carry must prove the record in question specifically pertains to that party. An exemption applies and the disclosure would not be in the public interest or would substantially irreparably harm that party or a vital government function.
Your Honor, so the case that I'm looking at is CU Healthcare 775 Northwest versus State, 193 Wash App 377. And that indicates that the exemption also applies to sorry, one second, please.
I think that's the case I'm looking at.
Is that the case you're looking at?
So, yeah.
So Your Honor, I guess the reason so Your Honor, could you ask your question again, please?
I guess under 4256-540, how does love overwhelming fit into one of those definitions?
Correct. And
the information being sought to be released is names, but not the name of love overwhelming, correct?
Your Honor, that's correct. But this is information. Information can be restrained not just by, of course, a party whose information would be released. In this particular case, Love Overwhelming was hired to do intake for individuals who were living outside at Alabama camp. These are people that they have built relationships with, and it would, so this was information that was provided by Love Overwhelming on behalf of, it was provided by Love Overwhelming, and in effect, this is, so it pertains to Love Overwhelming because they provided the information. They collected the information, and it would do grave damage to their operations. Your Honor, let me be pretty frank with you. I had to pull this together on pretty short order. I'm pretty exhausted from lack of.
It's just a very simple question, Kenza.
I understand. No, I get it. I
don't understand how we're not releasing information about love overwhelming.
Say that again, Your Honor.
There's no request to release information about love overwhelming, correct?
That is correct. That is correct. The information it was collected by Love Overwhelming. It relates to people that Love Overwhelming serve, and their service recipients. So I mean, the record really does pertain to them because this is, first of all, the intake forms. I mean, they have Love Overwhelming's logo. It has Love Overwhelming staff name. So I mean, there's definitely a connection to Love Overwhelming on the data. They were under contract with the city to provide this information. So for example, like in the Sue case that I think you and I are both looking at. That was not brought by, actual individual welfare recipients. That was brought by that was not brought by individual welfare recipients. That was actually brought by the agency, SEIU. It does not need to be brought by the actual individuals who are facing, release of records.
Mr. McNamara, any comments on that issue alone?
On standing, Your Honor, there's no dispute that Love Overwhelming was under contract to collect this information, and their name is on the top of the forms. I think that's really as far as it goes. Really, the information in the whole argument regarding release of information is as it pertains to the individuals living in the homeless encampment and the information regarding those individuals. I don't think Love Overwhelming is a person named in the record, except, as I mentioned, their name is on the letterhead or of the top of the form, or to whom the record specifically pertains. And I think it's a stretch to say that this record specifically pertains to Love Overwhelming. I think the record specifically pertains to those individuals who provided their information regarding living items and social services, et cetera. It would have been a simple matter, I think, for Love Overwhelming to have one of their clients serve as a plaintiff to establish standing. But standing is fundamental, and the city is not willing to waive the issue of standing in this case.
Let's see here just a second.
Your Honor, I'd further argue that this is information. This is information that belongs to Love Overwhelming. Love Overwhelming secured the information.
Well, on that part, Your Honor, we would disagree. I think the contract between the city and Love Overwhelming gives the city ownership of all work product.
And Your Honor, I would disagree with that. The contract that was signed with Love Overwhelming was in August of 2022. That contract did not contemplate that Love Overwhelming would collect this intake information. That contract was modified, and the contract also specifically stated that the contract could only be modified if it were modified in writing. There was no written modification that I'm aware of that there was no written modification to this contract that I was made aware of. So therefore, I don't know that provision that Mr. McNamara cites, that all of this is data that's owned by the city, would apply in this instance. Because if you look at the contract that says work product would belong to the city, this information is not specifically referenced in the contract.
I'm just re-looking at this. This is the SEIU case, which is the, just a second, let me get to that. It's 193 Wash App 377. And I read that, the case, I'm just quoting from the case, it says a non-governmental party, which Love Overwhelming would be, seeking to block disclosure under the PRA, must prove that the record in question specifically pertains to them. And I read that to be the record that's being requested to not be released, that an exemption applies when the disclosure would not be in public interest and would substantially irreparably harm the party or vital government function. And I guess that I took a look through, the city provided me with copies of the redacted documents and unredacted documents, so I knew what we were talking about. And the records that are being requested to be released, I mean, they pertain to Love Overwhelming only in that they were data collected by Love Overwhelming at the request of the city in order to do this program, which I'm not 100% familiar with how this all works into that, but that's where the data was collected. And so the information that's being sought is not, there's no information. I look at the information request and it doesn't necessarily ask for anything other than the information about the applicants. So I think unless I've got an applicant who's a party, I don't know that I have any jurisdiction to do anything because there's not a petitioner with standing that I can see.
So Your Honor, I would cite another case, Spokane Police Guild. And in that case, it holds that when an agency intends to release records to a requester under the Public Records Act, an interested third party to whom the records specifically pertain may seek to enjoin disclosure. And again, that's exactly what we are, in this instance, claiming that.
What's the citation on that case?
That's 112 Win 2D 30.
Just a second. So that lists the Spokane Police Guild, the nonprofit corporation, and Jerry Poindexter as president, and John Doe, who I assume was one of the named parties. So you have a plaintiff there. Let's take a look here. I didn't look at this case prior to this, so let me take a quick peek at it. I apologize if I'm not coming through loud, real clearly here.
Yes, I am having a hard time hearing you, Your Honor.
My apologies. I'm kind of mumbling to myself here. I haven't looked at this particular case, so let me. So it looks like, well, first off, that case was brought under 42-17-330, which was recodified by 42-56-54. I'm not sure if there's a difference in that language. looking for the language that you were quoting. So Ms. Walpole, where is the language you were quoting about bringing the petition on behalf of an individual?
Your Honor, I'm sorry, are we on the Spokane Police Guild case?
Correct. I'm just looking, you said that there's something in there saying that it can be brought by an agency, but not, I'm just, it looks to me like that case was brought by the agency and the John Doe, who would have been, I assume, the party who didn't want their information released.
Well, Your Honor, it occurs to me in this case, though, I mean, love overwhelming, in effect, it's not much different than the city of Longview moving to restrain, which is clearly, that's something the city could do. It's a lot of work for a municipality to do that. But in this case, the city of Longview contracted with the city of Longview contracted with love overwhelming. So in effect, there was an agency relationship. Love overwhelming was doing this information, was collecting this information on behalf of the city. So it just feels that in effect, the city could bring this motion and ask for the court to determine if an exemption applies. So love overwhelming should be able to do that as well, because in effect they were an agent. They had a contract with the city, and I just don't think that the city could create that level of distance by virtue of making them a contractor.
The city could bring this under the agency definition, but they're not.
Well, sure, but I guess in effect what I'm saying is, in effect, love overwhelming, they were acting as an agent of the city, so they have agency. They have agency to bring this, and I think that's actually an alternative way to look at why they would have standing. Your Honor, too, if you look at the nature of this, why are they an interested party? Well, how practical is it for 140 people these are people living on the street. They're not going to be able to come together. They're not going to be able to file their own lawsuit. This is something love overwhelming can do for them. So that's another reason they're an interested party, is they're interested in these individuals. They're interested in the welfare of these individuals, and these individuals, they're certainly not in a position to bring this lawsuit.
All right. Well,
Your Honor, if the court would like additional briefing on the issue of standing, I'm certainly happy to provide that. I would ask if the court could grant restraint, we're happy to bring further briefing. And, Your Honor, again, I know this is something the court probably doesn't want to hear, and the court might feel like, this is our problem, not the court's. But I would just ask the courts to recognize that this was a pretty complicated case we needed to bring on extremely short order. The purpose of a TRO is to maintain the status quo, and quite frankly, I think if given a little more time, we did the best we could with the time we had, Your Honor. For the last 4 days, I've been doing nothing but working on this court case, quite frankly. And I'm sleep deprived right now, and I'm not doing a very good job of answering your questions. And for that, I apologize. So I would just ask if the court could give us, if standing is Your Honor's major barrier to granting temporary relief, I would just ask that the court give me an opportunity to do some briefing, and I'm happy to come back better prepared to answer that question. And I think also, Your Honor, that we only need to show, this is a temporary restraining order. We only need to show a likelihood of success. So I guess I would argue the likelihood also would apply. It's likely that love overwhelming has standing. I just feel that we've presented enough to Your Honor that the court, should be able to maintain the status quo for a brief period of time, even if not 14 days, so we can answer the court's unanswered questions. I mean, I think in this case, Your Honor, the thing to keep in mind is what we're asking for is not unreasonable. I mean, all of these data points, a majority of these data points, they've already been released. What has not been released is individual names. It's not the data points we have issue with, it's just the individual names. So I think, I would ask the court not only, I know, I understand and I respect and appreciate the court's, interest in standing, but, I think I would ask the court to consider, really there is absolutely nothing to be gained by the public having names to associate with these data points. And it would erode trust in government service partners. Here, Your Honor,
hold on a second. I can't do anything unless I have jurisdiction, which comes from standing.
So again, I guess what I'm asking Your Honor to do is to restrain release. It doesn't have to be. I'm not asking for 14 days, but if I could have a brief period to answer Your Honor's questions about standing, because quite frankly, I did not see this question coming.
Mr. McNamara, does the city have any objection to a brief continuance? I'd probably be looking at him. I'd have to check with my assistant, who I think is on the line. I'm looking at this Thursday at 2, which looks like it may be available. I'm not sure.
Thursday at 2, let me check, Your Honor. That would be available to me. I don't have a strong objection to this, Your Honor. I do have to say that, I think we did indicate to Ms. Aguirre a date by which we would be released these records. We were then contacted by Ms. Waldvogel. I think we held off on releasing them. And, and she's probably aware that, if we set this over for any period of time, that's additional time where, that she's not going to get the release. The city has a good faith obligation under the law to provide the records in a reasonable period of time. And the city is simply endeavoring to do what the act mandates that we do, apply the exemptions in a very limited manner as dictated by the statute, and to provide the records in a reasonable period of time. So I'm not going to stand in the way of Your Honor getting to a key issue in this case. And frankly, I'd hate to have it, the standing issue be resolved, against the city, and we could have gone forward. So I'm not going to object to a short recess of this hearing, or to the continuation of this hearing to establish the standing issue. But I just have to say, for the record, the city is endeavoring to provide a response to the requester in as quick and expedient manner as we are able under the circumstances.
Understood, and I have reviewed at least I won't say in depth, but I reviewed through the documentation your office supplied as to the records in question, so I'm familiar with what we're talking about. Ms. Aguirre, can you hear me?
I can.
Right, and you're the requester in this, and essentially, this is where we're at. The city is agreeing to release information for your request. There's been a request for certain parts of that, mainly the names of the individuals involved. I think there's here's where I'm at. If in fact there is an applicable exemption, I'm not saying there is, but if there is, if I were to not do anything today, that essentially throws any objection out the window. You very well may be entitled to receive all the records you've requested. I don't know that because I haven't heard all of the arguments on it. But what I'm suggesting is that I essentially order the city not to release any additional records until I have an opportunity here at this Thursday at 2. That would give all the parties some time to supply any briefing that they wish to for me to look at which point I'd be able to give an informed decision that complies with state law.
Okay, so Your Honor, I
Yes, ma'am.
I made the initial records request in October,
Mhm.
and then a letter was sent out to Love Overwhelming in February to have this matter done by February 14th. And now we're even farther into February. I'm just wondering, is this ever going to end? Like, in the contract, it says that all documentation is to be the city of Longview's. So I guess that's at what point is my records request going to be finalized?
Well,
I feel like I've been waiting for a really long time as it is since October. So I feel like there was ample time to get this done.
all right, and I understand where you're coming from, ma'am. I'm not minimizing that in any way. The court's not been involved in this matter up until essentially about 4 hours ago when I received a big stack of information from Ms. Waldvogel and Mr. McNamara. And I've had some opportunity briefly to go through the documents that were supplied. And what's important to me is we comply with the state law, which means if you're entitled to these records, you need to get the records. And vice versa, if you're not, and there's an applicable exemption, then that needs to be properly applied. I think the city has provided a great deal of information as far as all of the data points other than names of individuals. From what I'm understanding, I may be incorrect, at least I'm part of that, but that's what I understood. And so really this is a decision that would at least I would hear on this Thursday. It looks like I'd probably need to do that a little bit later based on what's I just got something from my assistant. Would 3:30 work for both of you or for everybody?
Yes, it would, Your Honor.
As opposed
Your
to
Honor,
2:30?
Your Honor, I have a very significant problem. I have a dog. Quite frankly, he is on his deathbed. He has an appointment Thursday at 3:30 with a specialist in Beaverton. I've waited for that appointment for a long time. When you said 2 o'clock, I'm like, great. I could probably go down there, set up someplace at 2 o'clock. I'm not going to be able to reschedule this. And I really, I hate to say it, but I really, 3:30, is just not going to work for me.
Well, I could do it Wednesday morning, probably. I don't know. Do you have any room available free on Wednesday? I know I've got the morning blocked out on my calendar here.
Give me one moment and I will take a look.
Or would you have a courtroom that'd be the big thing?
Your Honor, you'll probably get to this in a moment, but if we're going to be arguing this and having briefed it by Wednesday morning, I'd like to, if Your Honor would, when we get to that point, set a schedule. I know we're only talking about a matter of days or hours. At what point will I receive Ms. Wallbogel's brief on standing? And at what day and time would you require the city to file its response?
Let me see what time I can find you on Wednesday morning. I know the afternoon I can't do it, so I've got dockets all afternoon.
I understand.
Well, the other question would be, do you have anybody who could cover the 9 o'clock at juvenile on Thursday break? Because if everybody would be available at 9 on Thursday, we may be able to do it then.
I'm already bringing in coverage for some other stuff on Thursday. I can reach out and try to find somebody. I was also trying to contact the clerk's office to make sure we would have a clerk available.
Okay. Let me check something real quick here. I'm just trying to find a timeline here that will work for everybody. That.
And Your Honor, the briefing would only be on the issue of standing. Is that correct?
That's the only issue I need to know right now.
At this point, thank you.
That's the only issue that I see that's causing me challenging and giving you a decision right this minute. My alternative would be, it looks like I do it on Friday. Do we have, I've got.
Your Honor, I'm not available at all on Friday. And it's not just because City Hall is closed on Fridays. I have appointments all day.
Okay.
I'll set it where you need, Judge Basher. You have Wednesday morning. We can move some stuff around for you. Thursday, I would need to look into coverage for the 9 a.m. juvenile. And Friday, you are in a 1-day contested shelter care hearing.
Okay. That'll probably take some time. So,
The next option would be to go to the following week.
I'm inclined to do it this week if we can make it happen, just because of the circumstance of what it is.
Or we can do Thursday at 2 and I can adjust what I messaged you about.
Let's see if we can do that. Let's put it in at 2 o'clock on Thursday. And if we can move that other matter maybe till 4-ish on Thursday, if they're available to do that.
Yep, I'll work on that.
Yeah, 3:30 or 4. I don't expect this is going to be an extensive hearing. I just need briefing on this issue and then I can give you a decision fairly quickly. So let's do this. Given that I'm looking at Thursday then at 2, Ms. Walpole, if I could have your briefing by close of business tomorrow to myself, Ms. McGuire, and Mr. Lost my thing here.
McNamara, Your Honor.
McNamara. I lost you on my screen there. You disappeared. Sorry about that. And then have any responsive reading by 5 o'clock or 4:30 on the 1st.
Thank you.
Does that work for everybody?
It's fine with the city, Your Honor.
Ms. McGuire, I don't know if you're certainly welcome to file any legal briefing on this, and I'll certainly consider it. You're not required to. At this point, I've reviewed all the documentation. I can make a decision on Thursday once I get past this particular issue. So,
Okay, thank you, Your Honor.
okay. So we'll set this on for 2 o'clock on Thursday, the 2nd of March. I'll hear from Ms. Walpole by close of business tomorrow, and you'll need to provide that brief to Mr. McNamara as well as Ms. McGuire. I don't know if you can do that email, so that makes that probably easier for everybody if that's feasible. And then the same in response would need to happen by close of business on the 1st.
And Your Honor, this is a Zoom hearing again on the 2nd at 2 o'clock.
Yes, it would be.
All right, thanks.
I guess one question I have is close of business. I don't know when Mr. McNamara, if he's going to be working on this, Tuesday night, if Your Honor would, but if I could possibly have until Wednesday, first thing, like Wednesday at 9, that would be super helpful.
Your Honor, I don't think that's fair to the city to have to respond on such short order.
Well, close of business for the courts is 4:30, so that would be tomorrow at 4:30. And then 4:30 on the 1st for response. All right. In the meantime, I'm not gonna have a written order to this effect, but I will order that no release of any other information pending the hearing on Thursday.
Understood, Your Honor.
Ms. Aguirre, we'd be on the same kind of a thing. You go to our website, you'll be able to get the link and log back. Anybody else who wishes to sit in and watch, you're welcome to do that as well. All right,
Thank you.
all right. So I think that takes care of everything that's before me today. So we'll adjourn today. We'll see you all again Tuesday on the 2nd of March in the Zoom hearing.
Thank you, Your Honor.
Thursday, March 2nd at 2 p.m.
Thursday, March 2nd. It's been a long week already. All right. But we'll go ahead and adjourn today.